The forcible removal of a former president of the United States from a courtroom represents a rupture in the fabric of American political and legal history that few modern analysts had seriously contemplated, marking a definitive end to the era of presumed executive immunity in the face of judicial authority. The sequence of events that culminated in Donald Trump's expulsion was not merely a breakdown of decorum, but a systemic stress test of the judicial branch's ability to function under the weight of unprecedented executive defiance, a test that the system passed only by resorting to its most extreme coercive measures. When court officials intervened to physically escort the former president from the proceedings, the imagery transcended the immediate legal dispute, signaling a violent collision between the theoretical equality of the law and the practical power of a political movement leader commanding millions. This was not a sudden aberration, but the inevitable kinetic result of a legal strategy predicated on total institutional disruption, a calculated gamble that the court would blink before enforcing its rules against a figure of such historical stature. For weeks, the dynamic inside the courtroom had been deteriorating, characterized by a deliberate testing of boundaries that moved beyond vigorous defense into the realm of performative obstruction, with the defendant repeatedly challenging the judge's standing, the prosecutor's motives, and the very legitimacy of the proceeding itself. The judge's decision to order removal, a nuclear option, was reached only after every intermediate mechanism, from admonishments to sanctions, had been exhausted and ignored, leaving the court with a binary choice: abdicate control of the room or physically remove the source of the disruption. This specific escalation creates a profound paradox for the American justice system. To maintain its legitimacy, the court must enforce its rules without exception. Yet in enforcing those rules against a figure of such magnitude, it risks fueling the very narrative of persecution that the defendant utilizes as a political accelerant, effectively playing into a strategy where martyrdom is more valuable than acquittal. The silence that reportedly fell over the gallery as officers approached the defense table speaks to the cognitive dissonance of the moment. The visual of a man who once commanded the world's most potent military being subject to the physical constraints of bailiffs is a shattering of the imperial presidency aura that has shielded executive actors for decades, stripping away the mystique of the office to reveal a private citizen subject to the state's monopoly on force. Legal scholars observing the proceedings note that this removal serves as a definitive answer to the constitutional ambiguity regarding whether a former head of state retains a residuum of sovereign immunity in his person. The answer, delivered not in a complex written opinion, but in a visceral, physical action, is a categorical no. However, the tactical calculation by the defense team appears to have been precisely to provoke this outcome, betting that the image of their client being silenced would resonate more powerfully with the electorate than any legal argument could. By forcing the court to exercise its ultimate coercive power, the defense transforms a complex procedural trial into a binary clash of wills, shifting the venue from a courtroom governed by evidence to a media ecosystem governed by outrage, where the details of the indictment are lost in the spectacle of the conflict. The immediate consequence is a paralysis of the trial's standard rhythm, replacing cross-examination and evidentiary submission with a chaotic struggle for control that threatens to overshadow the substantive charges at hand, turning the proceeding into a referendum on the judge's temperament rather than the defendant's conduct. This event forces the judiciary into uncharted territory, where the standard tools of courtroom management are rendered insufficient against a defendant whose primary objective is not necessarily acquittal in the traditional sense, but the delegitimization of the tribunal itself as a tool of political suppression. As the doors closed behind the former president, the atmosphere inside the room reportedly shifted from tension to a surreal vacuum, a recognition by all present, prosecutors, defense counsel, and clerks alike, that the proceeding had crossed an invisible threshold from legal adjudication to historical crisis. The implications of this removal extend outward to every other jurisdiction currently processing cases against the former president, setting a new baseline for conflict that suggests future proceedings will not be standard legal inquiries, but high-stakes battles over the very authority of the state to judge its former leaders. forcing every other judge on the docket to recalibrate their own strategies for maintaining order in the face of a litigant who has proven he will accept nothing less than total dominance of the venue. This was the moment the theoretical collision between the unstoppable force of a populist movement and the immovable object of the rule of law became physical, tangible, and irreversibly damaging to the norms that have held the American Republic together for 2.5 centuries. The ripple effects of the courtroom expulsion were immediate, traversing the short distance from the courthouse to the corridors of political power in Washington with the speed of a financial crash, instantly reshaping the calculus for every major player in the American political landscape. For the Republican Party leadership, the incident presents a strategic nightmare that exposes the deepening, perhaps unbridgeable, fracture between institutional conservatism and the populist energy that currently drives the party's base, forcing a reckoning that leadership has tried to postpone for nearly a decade. The dilemma is binary and unforgiving. To condone the defiance of a court order is to align oneself with lawlessness, potentially alienating the critical suburban moderate voting bloc necessary for general election viability. Yet, to condemn the former president's behavior is to risk immediate excommunication by a primary electorate that views the judicial system not as a neutral arbiter, but as a weaponized arm of the political opposition, a deep state construct designed to disenfranchise them. Analysts note that the silence from many senior GOP officials in the immediate aftermath reflects a paralysis of strategy, a wait-and-see approach that is increasingly untenable as the legal confrontations accelerate and the demand for loyalty oaths becomes more strident. This event effectively destroys the firewall strategy many Republicans had hoped to maintain, wherein they could support the former president's policies while gently distancing themselves from his personal legal entanglements. That separation is no longer plausible when the confrontation involves physical removal by law enforcement, for the party is now forced to choose between the rule of law and the leader of their movement. Simultaneously, the legal implications for the defense team are catastrophic in a conventional sense, though potentially advantageous in a political one, creating a bizarre divergence between legal and political interests. From a procedural standpoint, a client who cannot be controlled is a liability that invites harsh sentencing and adverse rulings on evidentiary motions. The judge, having now expended the ultimate sanction of removal, is liberated from the fear of escalating too far, effectively calling the defendant's bluff. The worst has happened, and the proceedings continued, proving that the court can function in the defendant's absence, which fundamentally destroys the leverage of disruption that the defense had been banking on. If the trial can proceed without the defendant present, the strategy of chaos loses its ability to halt the machinery of justice, turning the defendant from the star of the show into a ghost in the room. Furthermore, this sets a permission structure for judges in other jurisdictions, Georgia, Florida, New York, Washington, D.C., to adopt similarly aggressive postures, knowing that the precedent for removal has been set and the sky did not fall, emboldening the judiciary to treat the former president like any other unruly defendant. Prosecutors are likely to use this incident to argue for stricter bond conditions or even gag orders, citing a demonstrated pattern of obstruction that goes beyond speech and into the realm of physical interference with the administration of justice, arguing that his presence is a clear and present danger to the orderly conduct of the trial. However, the risk of backlash remains acute. By physically enforcing its will, the court provides visual ammunition to the argument that the justice system is engaged in a humiliating ritual rather than a fair trial, potentially tainting the jury pool irrevocably. This dynamic creates a dangerous feedback loop. The more the courts assert authority, the more the defendant's base perceives tyranny, and the more radical the political response becomes, potentially inciting unrest or threats against judicial officers. The institutional friction here is not just between a man and a judge, but between the slow, deliberate processes of 18th century constitutional law and the instant, volatile demands of 21st century populist politics. A clash that the founders may not have fully anticipated. As the shockwave settles, it becomes clear that this removal has stripped away the polite fictions of American politics, revealing a raw power struggle where the norms of deference that once greased the wheels of governance have completely evaporated, leaving behind a naked contest for dominance. The donor class, too, finds itself in a precarious position, wary of funding a candidate who is literally at war with the legal system, yet terrified of the populace wrath that follows any defection, leaving the financial engine of the party sputtering in uncertainty. This is the moment where the legal timeline and the political timeline crash into each other, creating a singularity where every legal ruling attracts a political response and every political speech invites a legal sanction. In the ecosystem of modern media and public perception, the removal of Donald Trump from the courtroom was instantly transmuted from a legal procedural failure into a potent cultural weapon, accelerating the fragmentation of the American public into two distinct epistemic realities. The speed of the narrative bifurcation illustrates the deep epistemological divide in the American polity, where facts are curated to reinforce tribal identities. For the legacy media and institutionalists, the event was framed as a grim vindication of the rule of law, a necessary, if painful, reassertion that the judiciary remains the ultimate check on chaos, proof that the system can still withstand the pressure of a demagogue. Coverage focused on the unprecedented nature of the defiance, the stoicism of the court officers, and the systemic necessity of maintaining order, portraying the judge as a guardian of democracy, holding the line against anarchy. However, within the alternative media sphere and the MAGA ecosystem, the same event was instantaneously repackaged as a martyrdom operation, a visual confirmation of the witch hunt narrative that has been cultivated for years. The imagery of the removal, regardless of the specific context of the outburst that precipitated it, was stripped of its legal nuance and presented as the state physically silencing a political dissident, a narrative that resonates deeply with a base primed to believe in the illegitimacy of the current regime. This narrative inversion is a sophisticated political technology that turns every institutional sanction into an asset of insurgent legitimacy, flipping the script so that punishment becomes proof of virtue. Fundraising metrics likely spiked within minutes of the news breaking, capitalizing on the visceral anger of supporters who view the courtroom not as a hall of justice, but as a theater of war where their champion is being persecuted. This weaponization of the legal process renders the traditional concept of shame obsolete. In this new paradigm, judicial censure is a badge of honor, proof of the threat the defendant poses to the corrupt status quo, and a rallying cry for mobilization. The danger for the broader social fabric lies in the erosion of a shared reality. When a significant percentage of the electorate views the enforcement of basic courtroom decorum as a prelude to tyranny, the authority of court verdicts loses its stabilizing power, creating a crisis of legitimacy that no appellate court can resolve. We are witnessing the construction of a parallel legality, where the judgments of the state are deemed null and void by a large faction of the citizenry before the gavel even falls, creating a state-within-a-state dynamic that makes governance nearly impossible. This dynamic also complicates the strategy for the political opposition. For Democrats, the temptation to celebrate the removal as a victory for accountability is tempered by the realization that such celebrations only reinforce the accusation of politicization, trapping them in a double bind. They must navigate a narrow path, supporting the independence of the judiciary without appearing to relish the spectacle, a balance that is nearly impossible to maintain in the hypercharged environment of social media, where nuance is punished by the algorithm. The spectacle itself becomes the primary product, overshadowing the complex financial or statutory crimes actually alleged in the indictment, reducing the trial to a reality TV episode rather than a search for truth. The public's bandwidth for legal detail is limited. The visual of expulsion is absolute and requires no legal degree to interpret, making it a far more powerful meme than any legal brief. This simplification favors the populist narrative, which thrives on clear friend-enemy distinctions, rather than the institutional narrative, which relies on an appreciation for procedural complexity and the slow, grinding gears of justice. Furthermore, the role of digital influencers, who now serve as the primary news source for younger demographics, cannot be overstated. These actors often interpret such events through the lens of pure entertainment or drama, stripping away the civic gravity and reducing a constitutional crisis to content, further degrading the public's understanding of the stakes. Consequently, the courtroom has ceased to be a sealed chamber of adjudication and has effectively merged with the campaign trail, becoming the central stage for the 2024 election, where the jury is not just the 12 people in the box, but the entire American electorate. Every objection, every ruling, and every recess is now a campaign event, dissected not for its legal merit, but for its polling impact, turning the justice system into a subsidiary of the political industry. The tragedy of the moment is the total subsumption of the law by politics. A state of affairs where no verdict can be accepted as neutral because the venue itself has been redefined as a battlefield, ensuring that, regardless of the legal outcome, the political wound will fester for a generation. Zooming out to the macroeconomic and geopolitical horizon, the spectacle of a former American president being forcibly removed from a judicial proceeding introduces a layer of systemic risk that foreign capitals and global markets are beginning to price in with increasing unease, recognizing that the internal stability of the global hegemon is no longer a given. For decades, the United States has benefited from a stability premium, the assumption that, despite partisan bickering, its core institutions, the judiciary, the transfer of power, the rule of law, were immutable bedrock that underpinned the global financial system. This event, and the chaotic trajectory it implies for the coming election cycle, fractures that assumption, suggesting that the U.S. is entering a period of prolonged institutional volatility. International allies are watching, with a mixture of horror and pragmatic calculation, wondering if the internal cohesion of the U.S. is fraying to the point where its external commitments, security guarantees, trade deals, intelligence sharing, can no longer be guaranteed or trusted. If the domestic political system is consumed by a cycle of retribution and legal warfare, the bandwidth for managing global crises, from Eastern Europe to the Indo-Pacific, diminishes, creating a power vacuum that revisionist powers are eager to fill. Adversarial nations, particularly Russia and China, are already leveraging the imagery of the courtroom removal to propagate a narrative of American decline, arguing to the global South that the U.S. model of democracy is chaotic, vindictive, and fundamentally broken, and that their authoritarian models offer superior stability. This propaganda finds fertile ground in developing nations, where the moral authority of American lectures on governance is eroded by the spectacle of American leaders attempting to jail one another, stripping Washington of its soft power leverage. Economically, while the markets have historically ignored political noise, the prospect of a constitutional crisis or prolonged civil instability introduces a tail risk that could manifest in volatility for the dollar or treasury yields if the situation escalates to widespread unrest or a contested election result. Investors may begin to question the long-term safety of U.S. assets if the legal system, the guarantor of property rights, is seen as unpredictable or politically captured. The long-term danger is not merely the outcome of this specific trial, but the precedent it sets for the weaponization of the legal system by both sides in a tit-for-tat escalation that could paralyze the federal government for years to come. Once the taboo against prosecuting and physically restraining political leaders is broken, it is exceptionally difficult to restore. We are potentially entering an era of lawfare, where legal liability becomes a standard tool of political competition, a dynamic common in developing nations with weak institutions but alien to the American tradition. The resilience of the Constitution is being tested not by external shock, but by internal stress, identifying a vulnerability that the founders warned against: the rise of faction over public interest. The ultimate question is whether the electorate will punish the chaos or reward it, a decision that will determine the trajectory of the Republic for the next century. If the result of this legal confrontation is a restoration of norms, the system will have proved its durability, demonstrating that no man is above the law. However, if the result is a further splintering of the populace into irreconcilable camps, where one side views the justice system as illegitimate, the U.S. risks entering a period of anocracy, a hybrid state where democratic forms remain, but the substance of democratic governance is hollowed out by factional warfare and institutional decay. This scenario could even spark serious, albeit currently fringe, discussions about constitutional reform or a new convention, as citizens lose faith in the current structure's ability to manage conflict. The courtroom removal was a singular event, but its shadow stretches far into the future, signaling that the stability of the American Republic can no longer be taken for granted, but must be actively defended against the entropy of extreme polarization. The path forward is treacherous, with no historical map to guide a nation grappling with the trial of its own past president, requiring a level of statesmanship and civic virtue that seems dangerously scarce in the current political climate. This is the moment where the abstract concepts of civics class collide with the brutal reality of power politics, and the world is holding its breath to see if the center can hold. Historians may one day look back at this moment as the Rubicon of the American experiment, the point where the unwritten norms of restraint were finally abandoned in favor of raw power exercise, fundamentally altering the DNA of the Republic. This is not just a legal crisis, but an existential test of the Enlightenment ideals that formed the basis of Western governance, determining whether the rule of law can survive the pressures of 21st-century populism.